Okay, this is World Mission Society, Church of God versus Colón, BERL 5274-12. Counsel, could I have your appearances, please?
This is Marco Santori from Nesanoff and Miltonburg, representing the plaintiffs.
Okay, thank you.
And Paul Grosswald, representing defendants.
Okay, just hold 1 second, please. The reason why we are having this conference call today is a result of this court's prior order dated February 13, 2013. Relevant paragraph. Plaintiff provide by April 15, 2013 all documents referred to in the First Amendment complaint pertaining to the internet or text messages containing statements that are alleged to be defamatory. We are having a telephone conference call today instead of April 12 because it had to be rescheduled at the request of counsel. The application for motion to dismiss was denied without prejudice until determination of defendant's pending motion to dismiss, which will be heard on May 3rd, 2013 at 11 o'clock a.m. Okay, I was provided with a copy of what was given to Mr. Grosswald by plaintiff. It was dropped off at my chambers today. Why don't I hear from Mr. Grosswald first?
Okay, well, we have a couple of complaints about what they produced. The first issue is they did not produce an affidavit of completion. Now, I spoke to Mr. Santori before we called in, and Mr. Santori assured me that the affidavit of completion would be provided probably by the end of today. So I assume I'll just wait for that to come in, and if I have any further problems after I get that, then I guess I'll be back in touch with the court. But the other issues are that some of the statements they produced are not legible, which is one problem. But also, a lot of the statements they just didn't produce. I mean, there's still a bunch of statements that they allege in the complaint which are missing from their production. So the question now remains, how are we supposed to bring the motion to dismiss? We're trying to argue that these statements are not of and concerning the plaintiff. To make that argument, we have to be able to show what the statement says. The statements in the complaint are very heavily edited, so we need to see the complete statements. We've produced versions previously to the court which are not of and concerning New Jersey, and yet the plaintiff disowns those statements and says that the statements we're producing are not the correct statements, so the burden is on them to produce the statements that they're suing over. And yet what they produced, they produced some of the statements, but a lot of statements are still missing. So,
well, I don't. I mean, if the statement is missing, then that is something that is relevant to the motion to dismiss. In other words, they're making an allegation based upon a claim that certain statements are out there on the internet, having to do with the causes of action on the internet. This court has directed that the basis for those allegations in the complaint must be provided. You've now been provided with what they are relying on. So they can't produce something they don't have, but it would seem as if they haven't given it to you, that would inure to your benefit at the time of the motion to dismiss.
Yeah, no, it would. Okay, well, so fair enough. So then we'll make those arguments on the motion to dismiss then. But as far as the documents they produce that are not legible, for instance, the very first page of the document production is very difficult to read. So
yeah, I noticed that too.
Can't get a cleaner copy.
I mean, it seems to me though what it is something written by James Newton. Is James Newton now a defendant in this action?
Yeah, well, that's Tyler Newton. They allege in the complaint that the defendant Tyler Newton was using the name James Newton. So they're alleging that this was by the new defendant Tyler Newton. And they're claiming that Ms. Colón is liable for it under a conspiracy theory of liability.
Okay, I mean, I agree with you as to the first page. I think it would be fair to ask plaintiff's counsel to provide you with, and the court, with a typed copy of what this says. It's not that long. I think that first page needs to be typed because we can't read the copy that was provided to us.
Maybe I could make a suggestion. This is Marco Santori. What I can do is provide you with the original image that we have, that we printed out, and that's our best copy. And so rather than sort of expose ourselves to Mr. Grosswald's, potentially claiming that we mistyped or misinterpreted some of the things, I think it would just be best if we produced it in its native form, and Mr. Grosswald can, type it up as he sees fit. He'll have everything that we have.
Okay, what other, that's the only page I couldn't read.
No, I agree.
If you have any other pages, I'm happy to send you our originals or whatever you want to see.
I mean, I didn't read every single page, but I perused it.
Okay.
Okay, so that's the next issue. And what else, Mr. Grosswald?
Well, I was also going to point out that with respect to the videos, that there are supposedly, audio video statements, and they produced a screenshot of the video, but they didn't produce any kind of a transcript or text of it. I guess, so again, on the motion to dismiss, we would argue that they failed to produce it. Now, I don't know.
Whoa, I missed that. Where is there an audio video? Oh, here it is. I see. It's on page 24, mind-controlled cults, and then there's an arrow.
No, that's not it. Hold on. All right, the video is on page, hang on, I have it here. Just give me a second. Page 43.
Okay, hold on. Okay, I see this. Is the claim that Ms. Colón is the author of this video?
Yes.
I'm asking plaintiff. Is it your claim Ms. Colón authored this video?
Yes.
Okay.
Now, if the court, I think, well, this is kind of in the context of a larger position statement, so maybe I should just let Mr. Grosswald finish rather than responding in piecemeal.
Well, basically my point is that they're producing a screenshot, but they're not alleging that the screenshot is defamatory. They're alleging that the words spoken in the video are defamatory, and so there's nothing in that screenshot that reveals what those words are. Now, we had produced, Ms. Colón had transcribed the videos and produced them with her affidavits in the previous motion that we filed, and we were going to rely on those to say that the statements are not of and concerning New Jersey. Now, if the plaintiff is going to argue that Ms. Colón did not transcribe it properly, then I think the burden is on them to produce their own transcription, and they didn't produce it. So
or do you want the video on a disc?
If they can produce that, sure, that would be helpful.
Okay, that would work as well. Okay, next, Mr. Grosswald.
Well, then that's it. Then we have to set a briefing schedule for the motion.
Okay, so why don't you respond to those issues, Mr. Santori?
Okay. So let's see. I think that the issues that are outstanding after that are that the main issue seems to be that we didn't produce copies of all of the statements. So I just think it's important to be very specific here. What exists on the internet right now and what we allege in the complaint are not necessarily the same thing.
Well, that's your burden of proof. That's not Mr. Grosswald's problem. This is the statements you're claiming you based your complaint on. No.
So
then how are you going? Okay, if you're saying that there's things that you're basing a complaint on that you can't give us, where are you going to prove that from?
Well, it's important to, like I said, it's important to be specific. Mr. Grosswald made document requests.
No. I remember this exactly, okay? And you're very good with the words, Mr. Santori, okay? You were to provide to the plaintiff, to the defendant, the posts on the internet, statements on the internet communications upon which your internet defamatory allegations are based. If you're saying you can't, then that's your response. If you're saying this all we have now, then that's your response. I mean, it was very clear. There was no confusion when we left.
Respectfully, Your Honor, if we were responding, were we not responding to document requests?
Okay, let me read to you what it says in my order. Okay, this is a motion to dismiss. You have a huge complaint. Okay, I'm not going to reiterate everything I said when we were in court that day. And the majority of your allegations have to do with defamation via the internet. Not all, but most. And the thrust of the motion to dismiss is, what are you basing your complaint on? What are the internet postings, statements, videos, what are you saying was defamatory that was authored by Ms. Colón? And was also a question of, and how were you, well, let's just take one issue at a time. That is why I specifically wrote, plaintiff shall provide by April 15, 2013, all documents referred to in the first amended complaint pertaining to the internet or text messages containing statements that are alleged to be defamatory.
Okay, then I think that the short and simple answer is that that's all we had in our custody, possession, or control, or whatever the standard is.
Okay, that's
Yeah,
that's
I
it.
hear what you're saying.
Okay,
That's
that was the essence of what the motion to dismiss was about, and your position at the time was, oh, we don't have to give that now. We're going to do that in discovery. I said that the court respectfully disagrees. If you're going to be making this complaint, you need to provide to the defendant at this point in time that upon which you are basing your complaint. You had indicated that you wanted to rely upon expert discovery through various sources to determine what was written, when, who made hits, and you're going to do some sort of analysis without direct proof, but a generalized analysis of how many people read certain posts and things of that nature. While I understood what you were saying, I said at this juncture of the litigation, you need to give to the defendant that upon which you are basing your complaint, or I should say your first amended complaint, allegations of defamation via the internet by Ms. Colón. Okay, so if these are the documents, these are the documents. Okay, now, in terms of the video, please provide a disc of the video. This is on YouTube. Okay, please provide a disc of the video.
There's two videos in the complaint on YouTube that are discussed.
Okay, well, if they only produce...
There's one called Destroying Families video and another called Financial Information video.
Well, if I would ask that both of those be produced. I don't know what you're considering the one on page 43. And then we also have, let's see, what other issue was there? What's going on with the other defendant? I know that there was going to be a question of service and, jurisdiction. I mean, where are we in that?
Well, no, I've agreed, this is Mr. Grosswald, I've agreed to accept service on Mr. Newton's behalf without waiving personal jurisdiction.
Okay, that's right, that's right.
On the motion to dismiss, we're going to argue that there's no jurisdiction over him, but not doing formal service.
Okay, so you're going to be submitting those papers?
Right, but we need to have a schedule because you initially said my papers are due tomorrow, which is not enough time to respond to what they just produced. So.
And the basis of the jurisdiction of Mr. Newton is what? I'm directing that to plaintiff. I know you started the action in, was it Virginia, West Virginia?
Virginia.
Virginia, and it was dismissed.
Right. It was begun in Virginia and dismissed as to Ms. Colón on the basis of personal jurisdiction, and then it continued as to Mr. Newton, but then was discontinued without prejudice.
Correct.
And we refiled it here. So as to the basis of our jurisdiction, I'm reluctant to commit to legal theories over the phone without having briefed it properly first.
Okay. Just hold on a second. Okay. I voiced my concerns about this entire complaint and this entire cause of action, and I've had opportunity since our last meeting to do more research and develop additional thoughts on this type of litigation. At the present time, we have a May 3rd return date on the motion to dismiss. Today's April 16. I mean, at this juncture, we know the documents upon which plaintiff is relying for its claims is against Ms. Colón, correct?
Well, we know the documents that they produced.
Well, that's it. This is it. These are the documents.
I think at this stage, we have just the documents.
In answer to your question,
we have.
Right, at the present time, just so we're all, I understand, these are the documents upon which the complaint or the first amended complaint was prepared. Okay? issue as to Mr. Newton is really separate and distinct from Ms. Colón at this juncture, because the motion to dismiss as to Mr. Newton is going to be predicated on jurisdictional issues, correct?
Correct. We have
Okay.
we have a number of issues. He's also going to assert a immunity defense under the Communications Decency Act. So he's got a number of arguments.
Okay. How much time do you need to submit those papers?
I would say a week. I could do it by next week.
Oh, you don't have to do it in a week. Really, I don't think any of us can do anything like that in a week.
I mean, I've already written most of it, and I just left open the loopholes for whatever they were going to produce. So I
Okay.
tweak it. But all right. I mean, look, if you want to, maybe I'll take the 2 weeks, just so I'm not being squeezed. And if you're willing to give me 2 weeks.
Yeah, I mean, we can make the return date. We can make the return date May 24th instead of May 3rd.
Okay.
If that's agreeable to everyone, and then we can have Mr. Grosswald's papers due. Today's the 16th. You know. Why don't we have your papers due May 1st, Mr. Grosswald, and then we could have. I mean, I don't need any reply papers. Okay, I think. Well, that's important. Let me think. This. If you only need 2 weeks. So we have your papers due April 30th, Mr. Grosswald.
Okay.
And then we have Mr. Santori, your papers in by May 14. Is that okay?
Mr. Grosswald's papers are due the 4th, and then I would have until...
No. I took April 30th for Mr. Grosswald.
Oh, okay.
April 30th, and then 2 weeks after that is May 14.
Okay.
And then, and I'm going to give you page limitations, okay? And Mr. Grosswald, your reply May 21st, okay? Now the papers that you're going to submit, Mr. Grosswald, I would appreciate it if you could keep your pages to, is 20 or 25 doable for you? Because I remember the submissions last time were a little extensive. Okay, and I usually don't, I mean, I understand the issues. I mean, I would appreciate 20 to 25 pages, and I would ask Mr. Santori the same courtesy, please, between 20 and 25 pages for your opposition.
Okay, we'll do your...
The only issue there is I've got...
How much do you already have?
Yeah. I mean, I'm already up to 50, but that's
right. No, you said I had that sent.
200 pages of briefing on this motion already submitted.
Okay. You have 50 pages.
Hold on. But Mr. Newton's got his personal jurisdiction argument.
Right.
We're making a communications decency argument. He's also going to raise a comedy argument too, which is another argument. So I mean, that's.
Oh, you know what? I'm lifting the page requirement. You give me what you need to do. I will read it. I always do.
I will respectfully try not to waste your time with excessive pages. I will keep it as short as possible. And what I will do is I will cross-reference back. I'm not going to repeat like the trade libel argument, I'll just reference back that we've already briefed that issue, and I'll just skip over it. But then there's new issues that need to be briefed. I mean, we're also going to talk about Ms. Colón's. Ms. Colón has a divorce, and this case should be combined with a divorce under the entire controversy doctrine. That's another issue that has to be briefed.
Well, you're talking about Mr. Ortiz's direct claim, correct?
Yes, exactly. Right.
Yeah, I was going to ask Mr. Santori, why is that not part of the matrimonial action?
I think that this was covered in when we first all met at our first oral argument on this matter, and Your Honor asked you asked why wasn't this combined with the matrimonial action?
Which it still can be.
I'm sorry?
Which it still can be.
Right, and then in the context of that, we also asked, well, how can this really be an intentional infliction of emotional distress claim? And thirdly, why do we think that there is actually malice here? All of those are requirements that we had discussed the first time around, and the answer to that is the same answer, because unless this story is told all together, it just doesn't make sense. It would be next to impossible for us to explain why there's actual malice, why there's an intentional infliction of emotional distress, why the story all makes sense unless it's told together with the world mission story. And to tell it twice separately would just be, I mean, practically speaking, it would be a nightmare. Strategically, it just doesn't make sense to tell in two different stories.
But it also doesn't make sense to have the economic, to have the money of the two spouses divided up by a divorce court, and then also divided up in a civil court. I mean, the family court has the right to manage the divorce, and that includes resolving any torts between them. So, it just may be that that Mr. Ortiz has to litigate this in family court, and the church needs to litigate it separately. I mean, so you have two cases. It's two different plaintiffs. Their claims aren't the same anyway.
No, the claims are entirely different. Okay.
Right.
All right, so we touched base. I mean, the purpose of today's conference call was to discuss the submission that was given by plaintiff. And I look forward to your submissions having to do with Mr. Newton. And I'll see you all. Oh, let me give you a time. We're going to do this May 24. Ooh, that's Memorial Day weekend. Is that okay for everybody?
Hold on.
That's Memorial Day weekend. Is anyone planning on going away that weekend?
I think that
Let's make it.
my wife has ordained that, actually.
Okay, let's make it May 23rd. Okay. And why don't I give you a time of 10 o'clock, May 23rd?
Okay. Can we make that 11?
Oh, yes. I'm sorry. Yes. 11 o'clock.
All right, so just to review, so it's April 30th, my brief, May 14th, his brief, May 21st, my reply, and then the 23rd. So that gives you 2 days to read the reply. Is that going to be okay?
Please make your reply short.
Okay, all right, I will. Okay.
Okay. I was just going to say something else. Could someone just send me a confirming letter about today's briefing schedule? Why don't I ask Mr. Santori to do that?
Okay.
Just a confirming letter about the briefing schedule, and that this motion is going to be heard on May 23rd at 11. The motions will be heard on May 23rd at 11 o'clock.
Okay, will do.
Okay, and you're going to provide the
YouTube videos.
The YouTube videos, and you're going to be providing a certification of, what was the word you used? Completeness?
Complete affidavit of completion.
Affidavit of completion. Okay.
A legible version of the Facebook post.
And you're right, and a legible. Well, he's not legible. He's going to give us what he has.
Okay.
That's what was represented.
Right.
So we just have a confirming letter about those items. And
what is the plaintiff's deadline to provide those last remaining items?
A week?
That's fine.
A week? Okay, let's make that. Today is the 16th. Let's say by April 23rd, please.
Well, I mean, not to push the issue, but if I have 2 weeks to write the brief, I want to start my 2 weeks when I have everything. So.
No, we know what the videos are going to show. I mean,
okay, all right.
Well, you don't know. You haven't seen the videos?
Well, no, I know exactly what they're going to show. But,
okay, so
right.
It's not like it's going to be a huge surprise in any of this.
Okay, fine.
I mean, when you look at the video, there is a huge surprise. Write me a letter and tell me you need more time, okay? But I'm not anticipating that.
Yeah.
I think we all know what the deal. Our positions.
I was more concerned that if he doesn't produce them, and then I have to change my argument from he produced them and it shows this, or he didn't produce them and therefore,
Either way, Paul, I don't think that anyone's going to hold you up for time here.
No, and it's really just not about the videos. It's the whole picture. It's okay. So, all right, we have a plan. Thank you very much, and I look forward to seeing you.
Okay, thank you, Your Honor.
Okay, take care.
Thank
Bye.
you. Bye.
Mr. Santori is slick with his words.